Hi, and welcome to this latest immigration law update video. In this video, I wanted to look at a particular piece of Home Office guidance. That's the Home Office guidance on false representations. And the particular guidance at present, the particular version is version 2, and it's from the 6th of December 2019. So it's about a year old. But it's still very relevant because we are still seeing a lot of refusals under the general and suitability grounds on false representation and dishonesty basis, and references to TOEIC and tax discrepancy. So this policy guidance is particularly important. Some of the stuff I'll go through, it'll be useful to cite this policy guidance in your representations, your grounds of appeal, or your skeleton arguments. And it may also give you a basis to apply for administrative review or judicial review against a decision that hasn't got a right of appeal. So you can see the contents are set out there. It's a 12-page guidance. So this guidance is for caseworkers, including entry clearance officers, considering refusal on false representation grounds. First thing to do is note the definition of false, because it goes back to AA Nigeria, and it needs to be something that involves dishonesty or deception. So dishonesty or deception must be involved. And look what is said: an allegation of dishonesty or deception must not be made unless there is evidence to support the allegation. But false information can still result in a refusal under the rules where there is no evidence of dishonesty or deception. So if you're going to refuse under the general grounds, the Home Office must have evidence of dishonesty or deception. If they haven't and there's merely false information, they just may refuse under the substantive rules. So the types of rules that are applicable, there are the false representation rules that apply to false representations in the current application or in previous application. And there are public policy grounds for refusal. So public policy grounds, one we're very familiar with at the moment is 3225, which is often used in the tax discrepancy cases. And there's got to be, from Balajagari, both dishonesty and it's got to be sufficiently serious to refuse under the public policy grounds. And there's a background to Balajagari and tax discrepancy cases given in the guidance. And I'll put a link at the end of this video to my video on tax discrepancy case law. So in terms of the burden of standard of proof, while generally the burden is on an applicant to show they meet the rules, in respect of a general refusal under the general grounds, so part 9 of the rules or suitability grounds, the burden of proof is upon the Home Office, and they need to show dishonesty. And they give examples here of evidence that might include to substantiate an allegation. But look at this paragraph, really important, something you may want to cite. Allegations of dishonesty or deception are serious with significant consequences for applicants and their families. The legal standard of proof is the balance of probabilities. I'll pause there because previously it was assumed there was a variable standard within the balance of probabilities, and there's talk about the higher end of the balance of probabilities. A case called Re B in the House of Lords confirmed there is only one civil standard of proof. Let me carry on, which means that it's more likely than not that the applicant or third party has deliberately and dishonestly made false representation, submitted false documents or information, or failed to disclose material facts. It is not appropriate to refuse based on false representation simply because you are not satisfied that the applicant has given correct information. That's an important sentence. Even if the omission or incorrect information is capable of leading a caseworker to make the wrong decision. If you allege false representation, you must be able to show on the balance of probabilities that there was a deliberate intention to deceive. So again, very important paragraph, something you might want to lift out into your representations. And again, there's a procedural fairness element here that was introduced after Balajagari, that in circumstances you may need to give the applicant a chance to respond before you make a decision on the basis of a false representation. In terms of mistakes, you must consider whether an innocent mistake has been made. You must not refuse on grounds of false representation if it is likely that there's been an innocent mistake, or because there are minor but immaterial mistakes, such as typos, and an example is given there. So again, that's something, if you come across a case that's been refused on false representation grounds and your argument is it's an innocent mistake or that it's a minor immaterial mistake, this is something you might want to cite. And in considering whether something is innocent, here are some bullet points to have a look at. For example, how easy would it be to make an innocent mistake in these circumstances? So have a look at that, and you might want to address some of these bullet points in your representations. In terms of procedural fairness, after Balajagari, where the Home Office were found not to have acted procedurally fair and not to give an applicant a chance to respond before a decision was made, against which in a lot of those cases there wasn't a right of appeal, a minded to refuse procedure has been introduced, where the Home Office must tell an applicant they're thinking of refusing based on false representation, set out exactly what the allegation is, and make it clear that you're alleging dishonesty, and give a chance to respond. There must be a reasonable period to respond, and the circumstances where you must tell the applicant you're alleging dishonesty and give them a chance to respond is where both of the following apply. The applicant may not necessarily know about the information you've considered or its significance. For example, information obtained directly from another government department, and the example is given there. Obviously, if it's clear somebody would obviously have known about this information, the Home Office don't have to write and give a minded to refuse. And the implications for an applicant of a finding of dishonesty are significant. Well, that's always going to be the case in a dishonesty allegation and a refusal under the general grounds, which could lead to a re-entry ban. So I think it's number 2 is always going to be satisfied. In bold, then, you should also tell the applicant that you're alleging dishonesty and give an opportunity to respond if you're refusing on public policy grounds based on false representation. So if you're using one of the public policy refusal bases, you're going to have to follow a minded to refuse procedure. Now, these are something which may form the basis of a challenge by way of administrative review and later judicial review, where there's not a right of appeal and you don't think that proper procedural fairness and this minded to refuse policy has been followed. Obviously, if you've got a right of appeal in some recent case law, which I cover in my tax discrepancy video, the appeal will replace the sort of procedural minded to refuse process, so you can deal with all of that in the appeal. But if you haven't got a right of appeal, you might need to challenge by way of JR, and you can use this section of the guidance. Now, some of the general grounds are not mandatory, they're discretionary. In fact, as we know from Balajagari, 3225 is a discretionary provision. So whilst there's a presumption of refusal, a decision maker must consider all the relevant circumstances of a case. And this is really interesting. They may need to apply a minded to refuse process to gather the relevant information in respect of exercising the discretion. So not just a minded to refuse to address the actual false representation aspect, but also to provide the necessary information the Secretary of State needs to consider the discretion. Although in any application, you should be setting that out in any event. Mitigating factors will be looked at, and obviously any human rights considerations will also be looked at when addressing the discretion. And obviously where somebody applies for ILR but can't be removed for human rights grounds, but they would otherwise fall for refusal on false representation grounds, they may well be granted limited leave on human rights grounds as opposed to ILR. There must be a clear allegation of dishonesty as well. If the Secretary of State is alleging dishonesty, they must make it clear. Stating that they have doubts or concerns is not sufficient, and that was set up from Balajagari. So that is the false representation policy. It's a 12-page document. As I say, check you've got the current version. The version in this video is the 6th of December 2019. As you know, with any of my videos, do check for later updates from the Home Office, who are often changing and amending things. But this will be helpful in something to cite in your representation, in your grounds, when you've been refused on a false representation basis, or perhaps to challenge by way of JR, where the proper procedure has not been followed. I hope that's helpful. Thanks a lot.